5. How should I complete Immigration Eligibility Form I-9?
As an employer, you are responsible for completing a Form I-9 for everyone you have hired after November 6, 1986. I-9s appear to be an administrative burden for most employers, but that's because many companies fail to appreciate their responsibility in protecting our heritage of legal immigration. America has always been and will always be a melting pot, but the goal of the Immigration Reform and Control Act of 1986, IRCA, is to ensure that American companies employ only persons who have the legal right to work in the United States. That way, illegal aliens will not displace competent, qualified American workers or undermine prevailing wage standards. IRCA also attempts to prohibit discrimination against protected individuals, including citizens or nationals of the United States, lawful permanent residents, temporary residents, and persons granted refugee status or asylee status. Employers may not discriminate against employees on the basis of national origin or citizenship status. Note, however, that on an individual basis, you have the right to hire a U.S. citizen or national over an equally qualified alien to fill a specific position. However, you may not adopt a blanket policy of always preferring a qualified citizen over a qualified alien. Tell me more. Specifically, the law requires that you 1. Ensure that your new hires fill out Section 1 of Form I-9 on the day they start work. 2. Review documents that are presented to you in order to establish each employee's identity and eligibility to work. 3. Properly complete Section 2 of Form I-9 within 72 hours of a new hire's start date. 4. Retain Form I-9 for 3 years after the date of hire or 1 year after the person's employment is terminated, whichever is later. 5. Make Form I-9 available for inspection to an officer of the Immigration and Naturalization Service, INS, Department of Labor, DOL, or the Office of Special Counsel for Immigration-Related Unfair Employment Practices, OSC, upon request. When new hires fill out Section 1 of the I-9 form, they must be sure to sign and date the document, in the middle of the page above Section 2, on their first day of employment. Furthermore, they must be sure to check one of the 3 checkboxes indicating whether they are citizens, lawful permanent residents, that is, those authorized to work via a green card, aliens authorized to work here for a specified period of time, for example, those on H-1B worker visas. When new hires present you with documents that establish their identity and eligibility to work, you must examine the documents personally. If they appear on their face to be genuine, you must accept them. If you unnecessarily challenge a new hire's documentation or demand more than what Form I-9 asks for, you could be engaging in an unfair immigration-related employment practice. That could be seen as a form of unlawful discrimination. On the other hand, if the documents don't appear to be genuine or to relate to the person presenting them, then you must not accept them. Okay, easy enough, but what should you do if the person is unable to provide you with the required documents? For example, if the employee lost her Social Security card, simply inform her that as a means of demonstrating employment eligibility she must produce a receipt showing that she has applied for a replacement document. For example, she can fill out Form SS-5 at the local Social Security Administration in order to receive a receipt of application for the Social Security card. Once hired, that individual must present the actual document to you within 90 days of hire. In addition, the new hire must have checked in Section 1 of Form I-9 that she is already eligible to be employed in the United States. Furthermore, if the individual doesn't produce the original document or a receipt within 3 days of hire, you have the right to terminate employment. Similarly, If the employee has presented a receipt for a document but isn't able to produce the original document by the 90th day of employment, you again have the right to terminate employment. However, you're obliged to apply these practices uniformly to all employees. Fill out Section 2 of Form I-9 once you've inspected the new hire's documents. Section 2 is in the middle of the page, and you'll see that you're asked to examine either 1. One document from List A or 2. One document from List B and one document from List C. The reason is simple: listed documents establish both identity and employment eligibility. List B documents only establish identity, and List C documents only establish employment eligibility. Once you've filled out this documentation information, fill out the new hire's date of hire under the certification section, right above where you're asked to sign your name. Remember, you have 72 hours, 3 working days, not including weekends, from the date of hire to complete Section 2. Therefore, INS inspectors will typically look at the date of hire in the certification section and then look at the date you signed your name as the employer. If more than 3 days have lapsed between those two key dates, then you will be in violation. Once you've signed the document in Section 2, it is generally ready to be filed away,